Breaking news. UN and ICC reacted how Omotosho passed the judgment over Nnamdi Kanu. Hear the news in details. And please, I beg you to share this video if you have the love.
James Omotosho had fixed November 20, 2025 as the date to deliver its judgment in the terrorism trial against Nnamdi Kanu. This came after Kanu, who is now representing himself, stunned the court by refusing to open his defense. He insisted that there were no valid charges against him to defend. But my people, in a dramatic and unexpected turn of events, the storyline has changed completely. The headline you saw, Judge Omotosho makes shocking U-turn on Nnamdi Kanu's case. Abuja frozen, is exactly what is playing out right now. So, what exactly happened? The U-turn is not from the judge in the Federal High Court, but from Nnamdi Kanu himself, who has taken a bold legal step that has the potential to freeze the entire proceedings. Listen to this. Just a few days ago, on or around November 10th, Nnamdi Kanu personally filed an application before the Court of Appeal in Abuja. In this application, he is begging the appeal court to issue an order stopping Justice Omotosho from proceeding with the November 25th judgment. Why is he doing this? Let me break down his reasons for you in simple English. Kanu is arguing several key points: the issue of jurisdiction and repealed laws. He maintains that the court is trying him under laws that have been repealed, like the Terrorism Prevention Act of 2013. He says a repealed law is a dead law and cannot form the basis for a trial. He had raised this objection before Justice Omotosho, but the judge declined to rule on it immediately, saying it would be addressed in the final judgment. Kanu says this is legally wrong, that the court must first establish it has the power to try him before anything else. The right to defend himself. Kanu also told the appeal court that he had filed a list of witnesses he wanted to call, but only after the court first decided on the issue of jurisdiction. By refusing to rule on the jurisdiction and then foreclosing his right to call witnesses because he didn't start immediately, Kanu claims his right to a fair defense has been shut down. He fears that if the judgment goes on, he could be unlawfully convicted without having a chance to properly challenge the charges or present his side of the story. So, my people, the situation right now is this. The judgment scheduled for November 20 is hanging in the balance. The ball is now in the court of Appeal. If the appeal court grants Kanu's request and issues a stay of proceedings, the judgment on November 20 will be put on hold indefinitely until the appeal is determined. This is the freeze that the headline is talking about. However, and this is a very big however, some legal experts are already raising doubts about Kanu's chances of success with this application. Let me quickly share two major hurdles that people are talking about. The CJA hurdle, a very important law, the Administration of Criminal Justice Act, ACJA 2015, in its section 306, clearly states that an application for stay of proceedings in respect of a criminal matter before the court shall not be entertained. This means the appeal court may not even have the power to grant the stay that Kanu is asking for. The timing hurdle. There are also questions about the timing of his appeal. For interim decisions, a person has 14 days to appeal. The ruling on his no-case submission was delivered on September 26th, and some are arguing that the time for an appeal on that has lapsed. Can you see the twists and turns? This is why this case continues to captivate the nation. Now, while we are on this matter, let me quickly add another spicy ingredient to this pot of jollof rice. Just yesterday, November 14th, we got another breaking legal news concerning Nnamdi Kanu. Are you ready? The detained IPOB leader has also filed a fresh N550 million lawsuit against the Nigerian Medical Association, NMA, and 10 medical doctors. What is the case about? Kanu and his legal team are accusing the doctors of conspiring to issue a fake medical report about his health. This is a very serious allegation. They claim that the NMA never actually conducted a proper medical examination on him as ordered by the court, but instead wrote a report based on informal meetings they had with him at the DSS headquarters back in September. Why is this important? Kanu's lawyer, Maxwell Opara, claims it was this very medical report that influenced the court's decision to refuse him bail. So he is now seeking massive damages for that. This story is developing by the minute, my people. The legal battles are happening on multiple fronts. Will the appeal court agree to freeze the judgment? Will the N550 million lawsuit see the light of day? We have to wait and see. This is a good place to pause, but the gist is not over. I want you to understand everything clearly. So, in the next part of this video, we are going to look at the bigger picture and the different legal opinions surrounding this case. We will hear what some lawyers are saying about Kanu's chances. Now, a very important question many of you might be asking is, why is Nnamdi Kanu refusing to defend himself? It seems confusing, right? You have a charge against you and you refuse to open your defense. Let me explain the logic. In our legal system, the burden of proof is always on the prosecution. They are the ones who must prove beyond a reasonable doubt that you are guilty. Kanu's team is essentially arguing that the prosecution has failed to even establish a basic case that he needs to respond to. They are saying the charges themselves are faulty, the laws used are outdated, and the court lacks the jurisdiction. So, in their view, to stand in the witness box and defend himself would be to legitimize a process they believe is fundamentally flawed from the start. It's a high-risk, high-reward legal strategy. This case also touches on something bigger than just Nnamdi Kanu. It touches on the delicate balance between national security and fundamental human rights. On one hand, the government has a duty to protect the unity and security of Nigeria. They see Kanu's actions and speeches as a threat to that security. On the other hand, every citizen, no matter the allegations against them, is entitled to certain fundamental rights: the right to a fair hearing, the right to defend oneself, and the right not to be detained unlawfully. This case has become the central battleground where these two important principles are clashing. The way this case is finally resolved will set a major precedent for our judiciary. It will answer critical questions. How do our courts handle cases where a defendant challenges the very foundation of the charges? How far can the right to self-representation go? What is the limit of using stay of proceedings applications in criminal matters? The eyes of the nation, and indeed the world, are on the Nigerian judiciary to see how it will navigate this complex and politically sensitive case. My people, this is not just a story for the newspapers. This is a real-time legal drama that has implications for every one of us. It's about the rule of law, it's about justice, and it's about how our nation handles its most difficult challenges. As we wait for the next...
na Eastern News 24 beba isiwene weteru nyabu nnukwu ozi gbasata maka ya bife na-eme nụ ka efi were ikwu gbasata maka ya bife ndị wetere n'ụbọchị nketa n'iru akwụkwọ ka emesịa